excited for the second night in our series on the church and same-sex marriage. Some of you were here last week when Dr. Stan Saunders from Columbia Seminary kicked us off talking about the Bible and same-sex marriage. I think it was evident to those of us who were here that we could have spent many, many weeks just on that topic. He shared with us a lot, and there was plenty more that could have been said. So just want to reiterate that this series is not the end-all, be-all of this conversation. We're hoping it's a conversation starter. So feel free to talk with me or Todd or anyone on staff about how you could get Stan or someone else to come into your Sunday school class or any sort of small group and continue that conversation. Tonight, we are continuing the series with the same law and same-sex marriage, looking at both church and civil law. And I want to introduce our presenters for tonight. Our first presenter doesn't need a whole lot of introduction. He stands up in front of the congregation and introduces himself to you with some regularity. Bo King is an elder here at DPC. And you may see him with his wife Catherine and his 3 daughters around here. But he also has a day job where he works as an assistant federal defender in the habeas unit.
There you go.
And he defends death row inmates.
There you go.
All right. And I found out several years ago that he actually knows Stan Saunders, who was here last week, because Stan does a lot of pastoral visitation with some of our death row inmates here in Georgia. So he and Bo know each other pretty well. If you know Bo at all, are friends with him on Facebook, see him walking around with his coffee service tumbler, you may know that he went to Duke for undergrad and continues to pull for Duke. And he also went to NYU for law school, and we are...
and we don't understand why.
No one does.
There are lots of people who I think would have the knowledge to present on this topic for us, but I was thrilled when Bo said yes, because he is someone who loves this church and is loved by this church, and so I was thrilled that he would lead us through this topic. After Bo does his presentation, we will hear from Reverend Lindsay Lee Slocum, who is a senior associate pastor at Roswell Presbyterian Church in Roswell. She's been there for about 9 years. Mary Elizabeth and Andy know her well. The Montgomerys, right here. Her cheering section, right there. They were members at Roswell before they moved here. She's primarily responsible for discipleship there at Roswell. She graduated from Presbyterian College, and so she and I actually know each other.
Go Blue Hose!
Go Blue Hose! On PC. That's right. So we know each other from there, and then she went to Columbia Seminary as well. That's where she got her MD. We have some cheering for Columbia Seminary.
Pep rally going.
I know. We're off to a good start tonight. So I want to thank both these folks for leading us tonight, and I'm going to let Bo get us started. Thank you, Bo.
Yeah.
All right, hey everybody.
You're not asking
All
for
right.
money?
What's that?
You're not asking
I am not asking for money. If you want to give me some, I will take it. But I will make no assurances to what I'll do with it. All right, so lawyers like to start everything off with caveats. Let me talk about what I'm talking about and what I'm not talking about, because there are about 500 areas of law that are relevant for this. The one that seems most pressing is that we have oral arguments scheduled next week, in this case, with the super pronounceable name of Obergefell, that's my guess, versus Hodges. And the wide assumption is that this case is going to result in some recognition of a constitutional right to same-sex marriage. I'll break this down in just a second. So, it seems like the most immediate question that we should talk about is, how did we get here? This seems, in some perspectives, to have all happened very fast. I'm going to present some case law suggesting that actually you can make an argument that it's happened rather slowly. But we need to review all of the case law that has led to this point. I'm going to try and talk about the constitutional rights involved in as sort of, for lack of a better word, non-legal way as possible, since we all know talking about things in legal ways is confusing to lawyers especially, in my experience. So, let's start with the beginning. Next Tuesday, oral argument in Obey Obergefell, or whatever it is. This is actually 4 cases, each of the states in the 6th Circuit. So the country is divided up into federal circuit courts of appeal. There are a number of states in each circuit. We are in the 11th Circuit Court of Appeals, along with Alabama and Florida. So the 6th Circuit has the Upper Midwest, Kentucky, Michigan, Ohio, and Tennessee, and each of them had a case raising one way or the other the question of whether there is a constitutional right to same-sex marriage. The case is going up now on the 6th Circuit because, and we'll get into this a little bit later, the plaintiffs lost in the 6th Circuit, which was actually the first time in about a year that a plaintiff had lost. As we're going to talk about later, there have been about 29 cases that have gone the way of the plaintiffs just since the summer of 2014. So that forced the issue, that made the Supreme Court take it up. They could have picked one or the other. They took them all. We're going to consolidate you. And there are 2 questions before the court. Here's the first one. Does the 14th Amendment require a state to license same-sex marriage? Second question, does the 14th Amendment require a state to recognize it? So, clear example, if somebody, normally, if you get married anywhere, any state in the United States, certainly, and actually most other countries, if you then move to a state, that marriage is recognized. You don't have to go through some kind of separate ratification or certification or marriage. It's just accepted and brought in. That obviously has not been the case with same-sex marriage. So the question is, full faith and credit clause. Do we have to recognize a lawful marriage from another state? So these are the 2 questions that have been presented. And again, broad expectation is that plaintiffs are going to win. The biggest evidence that we have of that is that a federal judge's order invalidating Alabama's same-sex marriage ban was appealed on cert to the Supreme Court in January, after they had granted cert in Obergefell. They said, stay this judge's order saying that same-sex marriage is legal until you've argued Obergefell, and the Supreme Court said no. The fact that the Supreme Court said no is a pretty strong indication that they're going the plaintiff's way. If there was any chance that they weren't going to go the plaintiff's way, they'd probably stay it. Because otherwise you're in this sort of weird halfway zone that, as we'll talk about, California got in, where some same-sex marriages are legal, and then after a reversal, some are not. So this is the strongest piece of evidence we have. Broad expectation they'll win on both questions. There was a thought that the second question might be an out for the court, where they could say, all right, we're not going to say every state has to license same-sex marriage, but if there is a state that does, and then you move to a state that doesn't, that state has to recognize it. I actually think, and I can talk about this if you're interested, that that's unlikely. I think they're going to win on both questions. So, status quo, you can now legally marry in 36 states in the United States and the District of Columbia. How did we get here? It sure does seem like it happened fast. Starts with the 14th Amendment. That was a little while ago. Adopted in 1868 in the wake of course, the Civil War. There are 2 portions of the 18th Amendment, which is a long amendment with lots of clauses, but there are 2 clauses that are important here. Due process. No state shall deprive you of life, liberty, or property without due process, and equal protection. No state shall deny to any person the equal protection of the laws. Due process has been read to mean that we have what are called liberty interests in certain aspects of our life, in the most intimate and important aspects of our life. And those liberty interests go to things like who you marry, personal choices, broadly speaking. The argument that has been raised in the same-sex marriage context under this clause is, I have the right to choose my spouse. If I want to choose a spouse who is of the same sex, you should not interfere with my ability to do that. The 8th Amendment protects me. Next provision, the Equal Protection Clause. We don't have laws that discriminate against people. And so the argument here is very related. You can see how they kind of overlap in some ways. If I want to marry a person of the same sex and I can't, but you want to marry a person of the opposite sex and you can, then the law isn't treating us equally. It's making a distinction between the 2 of us. Now, which of these have prevailed in the courts up to this point? Both. Either. sometimes weird melanges of both. So basically, as you can see, there's a fair amount of overlap. It's hard to say which one. My brother is picking now to send me lots of pictures of his new backyard. Just throw that in there. All right, so how does this work in court? So you have a law that says same-sex marriage is not permitted in our state. It's challenged under one of these two arguments, right? It violates my right to due process, it violates my right to equal protection of law. Now, the question becomes, how hard is the court going to look at the law? Because if you think about it, we make distinctions under the law all the time. If you jaywalk, you're going to get a ticket. If you cross at the corner, you're not. Nobody's going to say that that's a problem. That's what laws are. But if you make a distinction upon some aspect of a person, some way that they can be classified, that we look at suspiciously, that we think suggests that you're coming from a place of some animus or discriminatory intent, we look harder at those. The two most obvious ones, race and gender. If you have a law that discriminates on the basis of race or discriminates on the basis of gender, a court is going to look very hard at that. Same with due process. Some liberties, again with jaywalking, I feel I have the liberty to walk where I want. Well, sure, but we're going to say you can't cross the street in the middle of the street. Nobody's going to get upset about that. But certain liberties, these most intimate liberties, these choices, these deeply personal choices about how you live your life, they're going to look very closely at any law that restricts that or arguably infringes upon it. So, how hard do the courts look at these laws? We have no idea. They have not been explicit in any of these decisions. In the decisions that we're going to talk about, the Supreme Court hasn't been very doctrinaire or very explicit about what they're doing. They just say, this doesn't look right to us. 3 times they have invalidated discrimination on the basis of sexual orientation since the 90s. 3 cases where they've said discrimination against people on the basis of their sexual orientation is not okay under the 14th Amendment. But they haven't said that sexual orientation is a protected class. And that's important for reasons that we'll get into. So they haven't been willing to say that your sexual orientation is the equivalent of your race or your gender. And so we're automatically going to give it this super scrutiny. But they have nonetheless given it some scrutiny and said, can't square this with the 14th Amendment. As my old professor used to say, is all of that as clear as mud? That makes some sense. Okay. So, almost obvious to say, right? The Due Process Clause says marriage is a liberty. This is a language from a case from 1888, Maynard v. Hill. The most important relation in life, the foundation of family and society. We don't have civilization or progress without marriage. That's how fundamental it is. 14 times since then, they have affirmed that in even more ringing language. The first time they used the legal magic words of fundamental right that I saw, 1978, Zablocki versus Red Hale, which is a fantastic case name. Right? So, do we have cases that have interpreted 14th Amendment protections in the context of marriage? We have a very famous one, Loving versus Virginia. It was back in 1967. Mildred Jeter, who is African American, and Richard Loving, who's white, marry in D.C. They actually live in Virginia. They're married in D.C. In Virginia, they're indicted. They're charged with miscegenation. There was 16 states that had those laws. They were sentenced to jail. But the judge suspended the sentence in one of these great, I want you out of my county by dawn rulings, along with this glorious paragraph. Almighty God created the races white, black, yellow, Malay, and red, and He placed them on separate continents. That was the problem, is that we started traveling to different continents and meeting Malay and red people, and, you know, that was the breakdown. He did not intend for the races to mix. You get the feeling that that land bridge between Asia and Alaska would just blow his mind. The question that goes up in Loving, very straightforward. Equal protection and due process. Would they sanction a law that prevents a marriage solely on the basis of race? No. Unanimous reversal. Again, here it is again, ringing language. Marriage, vital personal right, essential to the orderly pursuit of happiness. I don't know how much there is orderly about marriage, but go to it. To deny this fundamental freedom on race is directly subversive of the principle of equality at the heart of the 14th Amendment. I'm reading these because you're going to hear them again. You can't do this without violating due process of law. We will not allow freedom of choice to be restricted by invidious racial discriminations. This case echoes through many subsequent ones, right? Cleveland versus Board of Education. The court has long recognized that freedom of personal choice in matters of marriage and family life is protected by due process. Choices about marriage, family life, and the upbringing of children are associational rights. It's another magic word you'll hear. Who you choose to spend your life with, who you choose to build a life with, that's an associational right. So what did that mean for same-sex marriage? Well, there were challenges saying that same-sex marriage should be legal pretty soon after Loving. There have been challenges ongoing for decades. They've never gotten very far for the very simple reason that until 2003, in a lot of the country, it's illegal to be openly gay. So there were some other legal precursors to the consideration of whether you could marry someone of the same sex. The bigger issue was, can you be gay and, this is not an exaggeration, not go to jail? So, Bowers v. Hardwick, 1986. Guess where it's from? So, a police officer, this is going to be a theme for the next few cases we'll talk about. A police officer observes Hardwick in his own bedroom in intimate sexual conduct. There's a Georgia statute that criminalizes sodomy. It criminalizes all sodomy. Right? Same-sex, opposite-sex sodomy is against the law in Georgia. There is some evidence that it was fairly selectively prosecuted. Hardwick goes to jail. But he files suit in federal court and says this state statute is unconstitutional. I'm gay. And I can be gay. I have the basic liberty to be gay. And due process should protect me. Now, why isn't he raising equal protection? Any guesses? Is the populist party.
Because it was for heterosexual couples.
Yes, the sodomy prohibition is against everybody, right? Nobody can commit sodomy, so we don't have an equal protection issue necessarily. Due process, liberty interest. My liberty interest is, again, these associational rights. I'm gay. I want to be gay. Why are you saying it's criminal? Supreme Court says, sorry, 5-4. Look at the way the question is presented. They say this, you can always tell the way a Supreme Court decision is going from the first paragraph. How's this one? The issue presented is whether the federal Constitution confers a fundamental right upon homosexuals to engage in sodomy and hence invalidates the law of the many states that still make such conduct illegal and have done so for a very long time. The ground for this opinion, moral disapproval of homosexuality, is a sufficient ground to outlaw it. It is a sufficient ground to criminalize same-sex relationships. The opinion is, well, first of all, you talk about these cases that there's an opinion. There are 6 opinions in this case, at least. I stopped counting at some point. There are concurrences, there are 4 dissents. Everybody's writing, everybody's talking about some aspect of it that bothers them. But the upshot is 2 big things. Moral disapproval is enough. Secondly, there is no relationship between same-sex intimacy and families. These cases are very preoccupied, and I'm sorry, I don't want to be crass. These cases are very preoccupied with what gay sex is. What's it like? Who's doing it? Where is it happening? But there's no relationship that the courts acknowledge between sex and relationship. If it's not considered a part, there's no, the language is, I think, almost explicitly, there's no relationship between same-sex intimacy and families. And this remains the law until 2003. Now, a lot happens in the interim. We're going to have to duck back briefly. But in 2003, and until 2003, sodomy laws are still square with the Constitution. Then, once again, Texas has a homosexual conduct law. So what's the first big difference between this law and the Georgia law? Only for homosexuals. And again, police entered an apartment and observed Lawrence and another man engaging in a sexual act. The police spent a lot of time walking into people's bedrooms. They are arrested, and they say 3 questions. I think I might have skipped this slide. Oh well. Anyway, 3 questions are presented. It goes up to the Supreme Court. Only one asks explicitly, should Bowers be overruled? There were some people who were trying to wiggle in an equal protection argument instead. But the Supreme Court says, nope, bring it up. We want to hear whether the petitioners were free as adults to engage in this private conduct. 6-3, overruled. Bowers was not correct when it was decided. It is not correct today. It ought not to remain precedent. You don't see that a lot. You don't see them say, we were wrong then and we're wrong now. A lot of times they say, we revisited it and we reconsidered, and a lot of intervening events have happened. No, nope, in '86 we got this one wrong. Our laws and tradition afford, you can have some of this language again, protection to personal decisions relating to marriage, procreation, contraception, family. Persons in a homosexual relationship may seek autonomy for these purposes. So we're getting a long way now from there's no relationship between same-sex relationships and family, right? Remember this language from Bowers that I put up a second ago? How about this? That statement, we now conclude, shows that we didn't really appreciate the liberty at stake. And I won't bore you with this, but there's actually a long passage in the opinion saying, actually there really isn't a long-standing history in this country directed at homosexual conduct. There's a perception that there is, but there really isn't. Which is a topic for a whole other presentation. Anyway, the 2 big holdings from Lawrence. Moral disapproval. Now we're saying, no, this is not a sufficient justification to discriminate on the basis of sexual orientation. And they explicitly say, many times in many different ways, lifelong same-sex partnerships play the same role in people's lives as marriages do. That doesn't seem even as controversial now, I don't think. That in 2003, during oral argument in this case, they were, Rehnquist and Scalia are questioning the petitioner, saying, what about kindergarten teachers? I mean, can't we say, if we go your way, do we have to say that we can't prefer heterosexuals to homosexuals for kindergarten teachers? What's the justification? Moral disapproval. What? 2003, this is still an active dialogue that the court's having. Again, moral disapproval. We don't believe that the moral disapproval is sufficient. These are not trivial concerns, but profound and deep conviction. This is the court acknowledging that Bowers was considered a designation of second-class citizenship for gays and lesbians in America. And we were saying we can outlaw your personal choices based on moral disapproval of them. It ain't just about sex. In fact, saying that it's simply about sex demeans people in the same way that it would demean a married couple to say that marriage is just about sex. They say that they're just prohibiting sexual acts, but actually what they're doing is they're touching upon private human conduct in the home. Yeah, we have police officers walking into people's bedrooms. The statutes seek to control a personal relationship that, how about this for a hedge, whether or not entitled to formal recognition in the law, is within the liberties of people to choose, without being punished as criminals. So they're hedging, right? They're saying, we're not saying you can get married, but we're saying you shouldn't go to jail. Believe it or not, I don't want to sound sort of startled by that, but it is a really startling proposition, right? So, case is still a mess. O'Connor actually says Bowers doesn't need to be overruled. We've got an equal protection argument. Let's go with that. Scalia, Thomas, and Rehnquist dissent. And Scalia makes a point, which certainly has some force to it, right? Law is based on morality. We have laws because we think certain conduct is immoral. If we have this as a ground, the courts will be very busy indeed. The man can turn a phrase. Here's the other thing he says. This is a question for legislatures. Let me be clear. This, if you ever want to read some opinions where people are going, "Let me be clear. I got no problem with gay people." You got to read the dissents in this case. It is hilarious. But anyway, yes, clear. I got nothing against him. It's not that. But use the democratic process. Convince people that homosexuality is okay. Get these laws repealed. Thomas writes a separate dissent where he says, this is a really silly law. If I was in the Texas legislature, I'd vote to repeal it. But it's a question for the legislative process. Now, this argument has a lot of force for a lot of folks. It's a strange argument, I'll say, that come from a federal judge. Is the entire purpose of constitutional rights is so that you can challenge legislative actions by a majority that you say infringe upon your rights. So to some degree, Scalia is arguing against the existence of a huge part of his own job. But that's the argument, and that argument remains and resonates with a lot of folks. Scalia also makes this argument, he makes this argument in a bunch of different contexts. He says, win people over, convince them you're right, get them to pass a law. Okay. So, and he throws a boomerang. This is going to come up again in about 2 minutes. Taken to its logical conclusion, this opinion means you have a constitutional right to same-sex marriage. This dismantles constitutional law that permits a distinction to be made between these unions. If there is no legitimate state interest, that's a magic word we won't bother getting into, for disaffirmation of homosexual conduct, what justification could you have for denying marriage? So, I say a beginning of the same-sex marriage cases because, as I said, there have been many challenges over the years. But we're going to talk about the cases now, the Supreme Court cases in 2013 that laid the groundwork expressly for where we are now. And that really starts in Hawaii. In the case of, I ain't going to try, Bear v. whoever. Okay, so these guys. Supreme Court of Hawaii rules that you need a compelling interest in prohibiting same-sex marriage. This is another magic word, but this is the highest one. You need to show us that you've got a really compelling reason in saying that we can't have this, or we should have it. Now this raises that full faith and credit question. That's one of the questions before the court right now. Well, wait a minute. If people can get married in Hawaii, can't they then just move to Georgia? And then we have to recognize it. What's going to happen? So remember, this is 1993. Congress gets involved. The House Judiciary Committee convenes and they commission a report. And the report says we need a law because a redefinition of marriage in Hawaii is going to make a lot of people in same-sex relationships eligible for federal benefits. We don't want them to have federal benefits. So, we want a bill to, and this is the quote, reflect and honor a collective moral judgment and to express moral disapproval of homosexuality. That's the express language in the report. This came up during oral argument in one of the Supreme Court cases that we're going to talk about, and it was one of the most awkward moments you will ever see an advocate have in front of the court, where Judge Kagan read that to him. Oh wait, I'm getting ahead of myself. This is the law that gets passed as a result, the Defense of Marriage Act, called DOMA. How about those margins? 85-14 in the Senate, 342-67 in the House. Clinton signs it, it becomes law. Marriage is only a legal union between one man and one woman, as husband and wife. Spouse refers only to a person of the opposite sex. No recognition of same-sex marriages for a variety of federal purposes, which tee us up for the first of the 2013 cases, United States versus Windsor. Edith Windsor and Thea Spire. Same-sex couple together for 47 years. Again, these long-term unions, right? In 2007, they can get married in Canada, so they do. They go, they get married, they move back to New York, and then she dies. She leaves her entire estate to Windsor. She wants federal estate tax exemption. They say, no, under DOMA, we cannot afford you the estate tax exemption that you would be entitled to if you were an opposite-sex spouse. So, $363,000 in estate taxes. That case goes up to the court. The second case that goes up in 2013 comes out from California. In 2008, the California Supreme Court says State statutes limiting marriage to opposite-sex couples violate the California Constitution. Same-sex marriages start that day. A referendum goes through a few months later by a California electorate. You remember the referendum system in California that we all chuckle at when they do various things. Says opposite sex, it's very democratic. Opposite sex limitation on marriage. We're restoring that. So the California Supreme Court says, okay, that's a lawful enactment, but the marriages before the passage are still valid. So now you have some folks who got married before this happened, in between this space, you're married. After this space, you can't get married. So, two same-sex couples file suit in federal court. Just a weird little side note, their lawyers are the opponents in Bush v. Gore. Former U.S. Solicitor General Ted Olson and David Buis, I'm not doing well with the names today. The judge has a trial and says, I want you to present evidence on a lot of issues. How having same-sex parents affects children, whether same-sex marriages undermine opposite-sex marriages, the history of discrimination, the effects, including economic, of a ban. I want it all. And they have evidence for it. They have tons of evidence in this case. One question that comes up, I don't want to jump to it, we can talk about it. This one. This is a big one, right? Based at least on the evidence in California, it went very strongly for the plaintiffs. It could not provide any evidence to show that there was a harm to children from growing up with same-sex parents. Quite the contrary. What they found was that there was a lot of harm to children who were being raised by same-sex couples because of the instability and demeaning aspects of not having that union recognized. So that's how the evidence broke down there. So the judge overturns Proposition 8, says violates due process and equal protection. And remember all these magic words we're talking about? How hard are they going to look? This is the easiest bar for them to clear. Rational basis. You gotta have some reason. It doesn't have to make sense, but you gotta have some reason. The judge said you would never get away with a law premised on that made any kind of meaningful distinction between people on the basis of inequality you can imagine. That's how low the bar is, and it only applies in certain laws. The judge says, you don't even have that. And the state of California doesn't appeal. Like, we agree. This is Arnold Schwarzenegger as governor. He's like, yep, I don't want to appeal that. And so they actually have, this is important, supporters of Proposition 8 say, well, we'll appeal. And they take it up to the Ninth Circuit Court of Appeals. Now there's a principle called standing. I don't want to get ahead of myself, but from the beginning there's a question of, well, wait a minute, can they really appeal? What injury do they have? How is this law affecting them? The Ninth Circuit affirms 9-1 with a really narrow opinion, and I won't even get into it, I'm already out of time. I won't get into how narrow it is, but it's really narrow. It's basically saying, the only problem here is that you gave the right and you took it away. If you hadn't done that, we wouldn't have a problem. There wouldn't be a constitutional violation, but you can't give it and then take it back. Right? Supporters of Proposition 8 say, we're going to the Supreme Court. Now this is interesting. A lot of supporters of same-sex marriage do not want to go to the Supreme Court at this juncture. Everyone's looking and saying, it's too soon. We don't have the votes, it's going too fast. We're going to have another Bowers v. Hardwick on our hands. We don't want to go. But the decision is made by the plaintiffs, and actually by Buis and Olson, who admit to a lot of hand-wringing and anxiety and finger-crossing. We're going to take it up. Cases are argued, they're briefed. June 26, 2013, they are both decided. They are both decided by a single vote, 5-4. Same justices on each side. The California case is the easiest one to talk about. Dismissed for lack of standing. The state could have appealed. But just because you support this act and you don't want it overturned doesn't give you standing because you don't have an injury in fact. And this becomes very important. What the court says is, this act doesn't affect you. All of the people who are challenged, all the people who are appealing are in opposite-sex marriages. Nothing has happened to their marriage. Nothing has happened to their relationship. The argument that they're making is we are injured by the extension of marriage to same-sex couples. But that is an injury that the court does not recognize. And they do something very important. They say, the Ninth Circuit should have said the same thing. The Ninth Circuit shouldn't have heard your case. So the Ninth Circuit opinion, that very narrow opinion, is vacated. and the district court's opinion becomes the last word on the matter. This is the bigger case. Windsor, 5-4. DOMA is unconstitutional. Justice Kennedy writes the decision. Is it due process or equal protection? Your guess is as good as mine. There is a lot of liberty talk, which of course is due process, but he explicitly seems to rule on equal protection and also federalism, which is a weird little side note where he's like, well, we're really kind of interfering with what a state can do or not. So, this is the big language, right? Demeans a same-sex couple whose moral and sexual choice the Constitution protects, humiliates tens of thousands of children being raised by same-sex couples. I'm not going to leave this up for 5 seconds, but these are some of the federal benefits for which people were eligible who were in same-sex marriages that were recognized by, had been performed lawfully somewhere. These are the kinds of things that are now back in play. Scalia dissents and he throws another boomerang. He says, the majority arms well every challenger to a state law restricting marriage. Henceforth, these challengers will lead with the court's declaration that there is no legitimate purpose served by the law, and it exists only to disparage and injure. Oop. Yep. They were well armed indeed. The boomerangs come back around in the summer of 2014, and this is a remarkable timeline of events that nobody saw coming. Think back to all the folks in the Perry case in California who are like, I don't want this to go to the Supreme Court. I don't want another Bowers. Instead, it's a rout. June, the 10th Circuit. July, the 10th Circuit again. Utah and Oklahoma, same-sex marriage bans are unconstitutional. 4th Circuit, the 4th Circuit. Virginia, South Carolina, North Carolina, the 7th Circuit. All of these cases in September go up on a writ of certiorari. Court, you need to intercede, and the court refuses. The court denies all the petitions for certiorari. And that's a magic word too, but basically, you have to ask the court's permission to hear your case. They don't hear every case. They only hear the cases that they think are issues of pressing constitutional concern where they have to weigh in. In September of 2014, they're like, nope. We don't need to weigh in here. 9th Circuit, the next day, I'm sure they weren't waiting, I'm sure it was a total coincidence, joins the club. And what do all of these decisions cite? Scalia's dissents in Windsor and Lawrence. There is no legitimate interest furthered by the bans. Okay? Since Windsor, 29 federal judges have found 18 bans on same-sex marriage to be unconstitutional. And then in November, as we said, the 6th Circuit became the first circuit court to uphold a same-sex marriage ban, which is why they're in front of the court, right? The court can say, all right, well, we can sit this one out. Everybody's going one way, and we're comfortable with the way they're going. But now somebody's going the other way, and that's when they intervene. And that might be the existence. All right, so the Religious Freedom Restoration, we don't have time to talk about them, and it's a separate presentation anyway because it's very long.
Can I ask one quick question?
Yes.
If this goes through with
Yeah.
due process equal protection, what stops polygamous couples from coming forward and saying, hey, this is a personal liberty thing. I love these 2 women, I love these 4 women, I want to marry them all, they want to marry me, you have no right to say that we can't. How do you stop, I mean, not how do you stop, but what keeps those people from now coming forward? Because let's face it, it's out in culture now. There are 3 television shows with these lovely families and all their lovely children. And people are becoming a little more comfortable. Yes.
Oh, yeah.
Are becoming more comfortable with that thought.
It's a longer conversation, and I'm happy to come back. But no, seriously, marriage, though, an important thing to recognize is that there is the definition of marriage as the union of 2 people is what the court, no, hold on, this is important though. That is what the case law has considered the stable union. That's the cornerstone of civilization, is 2 people coming together, right? That's what they've said. No, I mean, no, it is. I mean, that's what the case.
DOMA said, but DOMA said unconstitutional.
No, DOMA was only talking about the traditional definition of man and woman, right? But what I'm saying is a big thread in the case law from the beginning is that it's 2 people. So that would be a harder argument is what I'm saying to make, because at that point you're saying marriage in all of its conceptions and all of its legalization here is 2 people. You can make an argument that yes, you're interfering with those same personal liberty choices. But there's actually a lot of argument on the other side that no, The reason that we as a government extend recognition to marriage is because we see a specific benefit from two. We see a specific benefit of two people being able to come together and raise children together and, share in personal choices about life.
How does the
It's a longer...
How does the decision that's going to be made on Tuesday on the federal, how does that affect Georgia?
It could affect the entire country. If they rule, as they are expected to rule, that the 14th Amendment prohibits a discrimination or a distinction, really they're the same thing, but I know one seems to have more sharper teeth than the other, between same-sex and opposite-sex couples, that those things can't stand under the 14th Amendment, then there's a constitutional amendment in 2004 that Georgia passed saying, basically outlawing same-sex marriage. The fact that it passed in 2004 was not a coincidence. It passed right after Lawrence v. Texas. Right? People knew this was coming. That amendment would be unconstitutional. The Attorney General of Georgia, Sam Owens, was giving a press conference today. He was saying, look, if they come down this way, we're going to follow the law. We're not going to be Alabama. We're not going to challenge this, and we're not going to try and jam it up and say that you're interfering with our state's rights. We're going to follow the law. So that constitutional amendment would effectively be struck down, and the Attorney General's office would not be defending it in court, based on what he said today. We're out of time. I'm happy to answer questions later.